because it is substantively nonsensical. And maybe some other things invade your personal freedom as well. But by answering the interlocutor by saying, "What do you mean, General? I don't know what you mean," and by pushing the questioner to take the wrong turn, the only price the nominee has paid is by faking out a few people in the audience who might say, "Gosh, this sounds a little bit like Bill Clinton saying it depends on what the meaning of is." But none of the questioners pushed him in that direction. In any case, self-reference is a deeper kind of source of meaninglessness. But as it turns out, those puzzles don't really give me an escape from a more substantive discussion of what issues are posed by the Roberts nomination. They don't give me more of an escape because the only requirement, as I read it, that Section 111 imposes, despite what a big sort of whirligig there is over it in some universities. Vanderbilt, I understand, at the suggestion of its dean, is devoting the whole day to debating the constitutionality of Section 111 under the First Amendment as its educational exercise about the Constitution. Despite all of that, I read Section 111 as meaning nothing more than that you've got to do something somewhere around September 17th that has some relationship to the Constitution. And what, after all, doesn't? I mean, the Constitution addresses everything from life to death and everything in between, property, states, the federal government. I was originally going to give the example of, well, you got to teach something about, well, related vaguely to the galaxy in which we live, somewhere around September 17th. But even that is arguably constricting because some things don't relate in any meaningful way to the galaxy. A particular Mozart requiem does not bear any particular relation to the galaxy. It's transcendental in a sense. But just take the proposition that even music and even the spirit are encompassed in the Constitution, and there we have it. We have satisfied Section 111. But of course there is the canon of construction that says you don't construe a statute in a way that renders it utterly meaningless, even if by doing that you avoid the sweat of a constitutional argument. And so we go back and forth about whether that makes it meaningless. Well, I won't bore you with that discussion. I only push in this direction to give myself a way of moving slowly into the topic and also to give you a sense of how endless are the possibilities of discourse under the Constitution and how hard it is to make a meaningful judgment of whether someone is well suited to leading the Constitution's exegesis in the United States. And remember, this fellow is going to be Chief Justice not just of the Supreme Court, contrary to the way some commentators refer to him. He will be Chief Justice of the United States of America. That's the official title. Chief Justice of you and of me, as it were. Well, turning to talk of the Roberts legacy, I've got very little choice but to play Hamlet without the prince. I've got to talk about the Roberts legacy even before we have a Roberts court. In a way, that's quite fitting, because as any of you who heard Roberts testify and then read the transcript or even looked at the newspaper excerpts could probably tell, there was a lot less there than met the ear. The Roberts persona was powerfully present. One could draw certain inferences about the spirit in which he might approach the job. He's friendly. He's brilliant. I can testify to that quite directly. He was a student in my constitutional law course in the fall of 1977. Even more significant, his grade didn't quite reflect his brilliance. But that often happens, and from now on I'll be able to use that as a wonderful example at the end of the course, not to put him down, but to say, you can actually get somewhere in this life if you get only an A- in this course. It's not required that you be at the absolute top in everything. I tell people about how Derek Bach gave me a flat B in one course, although I didn't until this moment name him as the person who gave me a B. And C, I still managed to survive. In any event, he's clearly brilliant. The few inferences that one could draw about the starting premises that Roberts would bring to the Constitution, about the constitutionally acceptable place of religion in public life, really nothing there in the testimony, or about the constitutional balance to be drawn between private property and values of community, one of the most fundamental issues. Really nothing there. The values of community, yes, we heard something about. The values of self-government, the values of democracy, and also the rights of property. But where the rubber hits the road and where one must decide where one ends and the other begins, nothing. The concrete contours of personal privacy in the contested zone where the state and the individual fight it out over certain basic decisions, or where the state fights it out with intimate associations, whether it be a married couple or the family more broadly defined, or something very unlike the family but nonetheless intimate. The contours of that aspect of privacy really were not illuminated. How one defines the boundaries of Congress's commerce power vis-a-vis the states, really a blank, as he was pressed on whether he would defer to Congress's factual findings on purely factual questions. Does a particular hapless toad, to use a phrase that he used in one of his environmental opinions, ever wander outside the boundaries of California? Yes or no? Well, if Congress held elaborate hearings, hired spies to follow the toad, considered evidence, put toads on the stand for all I know, reached conclusions, the court would hardly second-guess them. That much Roberts tells us. But if Congress says, we don't care if the toad spends its entire life in California, it's enough for us that the particular activity involved in this case, which is a building development in San Diego, which happens to take the toad and destroy it, is itself an activity that is somehow connected to commerce. Well, is that or is that not enough to make this an exercise of the commerce power? Roberts didn't decide that, but he thought it was a question that was not approached in a manner by his colleagues on the D.C. Circuit that was fully consistent with Supreme Court precedent, so it should be reheard. Well, that's an opinion of his that tells us a little about his view of that boundary, a little, but very little, and he wasn't really questioned in a way that would have shed further light on it. So the fears of those who care deeply about the environment or about global warming, that this is someone who would have too cramped a view of Congress's commerce power to protect the interests of mankind, went unexplored, and there's no basis for decision based on those views. Of course, one could decide a good bit of this through a concept that if Roberts were on trial, we might describe as a burden of proof. We might say, since Roberts is not accused of doing anything wrong, is not threatened with being deprived of anything to which he has a right, instead of his being presumed innocent until proven guilty, instead of the government bearing the burden of proof, this is much more like a job interview by the American people, the way both Biden and Kennedy tried to picture it. This is something he wants, to which he isn't entitled, and what's at stake isn't so much his rights versus the rights of the Senate committee. Burden of proof rules about how we act in the face of uncertainty, are apt here only if we understand this is not like a trial. Only if we understand that the question really is, should the public have to be satisfied that Roberts would be a safe custodian of the American Constitution and its chief interpreter?